Hearing in the test claimants appeals.
Yes, Mr. Stewart.
In this appeal, I appear with my learned friends, Ms Wilson, Ms Bograno, Ms MacLeod, and Mr Wilmot Smith for the revenue. Mr Aronson, Mr McGolan are for the respondents. If I was before Mr Justice Henderson, I would be saying there's only two of the usual team involved today, myself and Mr Aronson. Things change over time, people retire, die.
The case goes on.
The case is still going on. The case is still going on. So this GLO concerns the tax consequences of dividends paid from non-UK resident companies to UK resident companies and the onward distribution of those dividends. The claimants in this GLO, the FII GLO, are multinational groups, and it relates mostly, nearly all, entirely, to dividends paid within those groups. So typically 100% relationship, maybe less. By contrast, the other GLO in parallel, the CFC and dividend GLO, which in fact seems to have been entirely about dividends rather than CFC in the end, it concerns what are known as portfolio dividends, which is dividends paid to shareholders who hold less than 10% shareholdings in the companies, typically companies like insurance companies, etc., who have a wide portfolio of dividends. Prudential was the test claim for the CFC and dividend GLO, and that's the case that your lordships had an appeal, I think, year before last, perhaps, 2018, I think now. So that's been going in parallel with these proceedings, and as you'll be aware, there are other proceedings. Littlewoods, for instance, is a case which has been going in a way in parallel with these proceedings, and has had effect on the legal results in this case. There are two sets of provisions, UK tax provisions, under consideration. Corporation tax on dividends, foreign dividends that is, that's sometimes you'll see referred to as D5 tax. That's a bit of a historical matter. D5 was the case of an income tax that taxed foreign dividends. But it is in fact corporation tax that is being charged in the years in question. And so there's that, and then there's ACT, Advanced Corporation Tax. Corporation tax in the years that we are dealing with, which is from 1973 to 2009 for corporation tax was charged on foreign dividends with relief for double tax, for tax paid in the foreign jurisdictions. But it wasn't charged on dividends from UK resident companies. They were entirely exempt. And it is that difference in treatment that led to the challenge. ACT, by contrast, was paid on a dividend paid by a UK resident company. It was paid as a percentage of the dividend. In principle, it was corporation tax paid in advance, and so there was a provision for it to be set off against mainstream, what we call mainstream corporation tax, at the time when the company had to pay its corporation tax. I say in principle because, of course, it could be that the company didn't have any liability to corporation tax, or very little, and therefore the ACT wasn't set off. And that problem was exacerbated in the case of companies which were receiving foreign dividends. Because of the double tax relief, there was much less corporation tax charged on those dividends. And so they were in the position that they couldn't set their ACT, all of their ACT off against corporation tax. And that resulted in the ACT mountains that were discussed in the 1980s and 1990s. Where a dividend was paid, an ACT was paid on the dividend, the recipient of the dividend received what was called, if it was a company, what was called FII, franked investment income. And that's where the name of the GLO came from. And what franked investment income did primarily was to frank subsequent dividends by that company. The purpose of all this being that ACT was only paid once in any chain of dividends up a group or any chain of dividends, essentially. So the company that received the dividend received FII and didn't have to pay ACT when it distributed further on. Recipients of dividends where ACT was paid also received tax credits. Those tax credits could be used in a number of different ways. If the recipient was exempt from tax, so it was, for instance, an exempt pension fund or something like that, it was entitled to a repayment in cash of the amount of the tax credit, which was equal to the amount of the ACT that the company was liable for. Similarly, individuals who didn't have any liability to income tax, so those who had very low incomes, mainly relying on dividends, could recover the tax credit as well if they had no income tax liability. If they had an income tax liability, the credit was set against their income tax liability. There was one further feature, though, of the ACT system, which was called group income elections. And I think I have to say something about this because one of the cases that is relevant was all about group income elections. When a dividend was paid by one member of a group to another, they could jointly elect that for group income to apply, and that no ACT was therefore paid on the dividend. No ACT was paid on the dividend, but the recipient therefore didn't receive FII. They didn't receive a franked investment income. So when they paid a dividend on, unless that was also paid under a group income election, they would have to pay ACT. This system facilitated groups of companies such as BAT, who are the main test claimants, in paying dividends up through their UK group without having to pay ACT more than once. And what typically would happen in practice is that the companies would pay all the dividends up under group income elections until they reached the top company. And then when the dividends were distributed to the external shareholders, ACT would be paid. One of the reasons why that was done was that ACT could be surrendered to other companies in the group, but only downwards. It couldn't be surrendered upwards to parents. So if you paid the ACT at the top, you were always able to surrender it to every company in the group. It could be surrendered to another company, and that company could set it off against their corporation tax liability.
Sorry, just remind me, when you talk about surrendering ACT, what do you mean?
Well, literally that. You make an election or a claim, and the ACT that you have paid is treated as being paid by the other company.
Oh, I see.
Yes, it's almost an assignment of the ACT to a subsidiary.
Yes, and sometimes there could be payments made between the companies, but not typically. It's in a group. So the idea being that the company which paid the dividend and paid the ACT was not necessarily the company that was trading and paid corporation tax. And so it could be that this company that paid the ACT was a holding company, didn't have any corporation tax liability, but there were lots of trading companies underneath it. And so there would be a surrender. They could surrender it to the other company. The other company would be treated as having paid it and therefore could set it off against its corporation tax.
Really assigns the ACT credit.
Sorry?
It assigns the ACT credit. So that the assignee can use it as a set-off against its mainstream corporation tax.
in commercial terms. I think in mechanical terms, I think it's treated as the other company's treated as having paid the ACT. And therefore,
Okay.
Yes, but
that's the
in
effect.
effect, it's the assignment of the credit.
Yes, absolutely. And part of the complications in this case, in the computations, arose from the fact that there were all these assignments taking place of the credit surrenders of the ACT, and therefore deciding when the ACT was actually set off was a complicated process, and I think there are still some issues, if I'm right, possibly about that live before this court, because what you have to decide, just jumping on, is when the unlawful ACT was surrendered and then when it was set off. And that's not an obvious, there's no obvious answer to that. Because at the time, of course, nobody thought that there was any distinction between different parts of the ACT. There was just ACT. It's only in retrospect that we have to impose some kind of structure on all of this and say that that bit of the ACT is unlawful, was unlawfully charged, that bit was lawfully charged. That bit of the corporation tax was lawfully charged, that bit was unlawfully charged. One is set against the other, and the consequences can be very different for the computation of the restitution.
We dealt with some of these issues in Prudential.
We did, exactly.
And I think we've got some more pending for a future hearing in this case.
Exactly, my lord, yes. Yeah. But I was talking about group income elections. The difficulty arose because group income elections could only be made between UK resident companies. So if a UK resident subsidiary paid a dividend to a foreign parent, say resident in Germany, as with Hearst and Mittelgesellschaft, under UK law you couldn't make a group income election, and therefore they always had to pay ACT. And that was the complaint in the Hearst case, and it was held that that difference in treatment breached EU law. And that essentially the UK subsidiary ought to have been able to make a group income election with its foreign parent and not pay ACT. Now, that is a very quick overview, run-through of the provisions. I'm sure that your lordships may have read in some of the earlier decisions a more detailed description, but I think for the present purposes that's probably sufficient. The respondents' complaints, I'm now going back to the early days of this action, can be simply stated in a way. As regards D5 tax, they pointed out that the UK dividend is exempt, a dividend between UK companies, whereas a dividend from a non-UK company is taxed, although with relief for foreign tax. This had one important consequence, which was, in the UK situation, if the UK subsidiary had reliefs, loss relief, for instance, or other capital allowances or other reliefs, they would use those reliefs, reduce their corporation tax liability, and then pay the dividend up, and it would be exempt. So the reliefs would be, in a sense, retained. They wouldn't be in any way lost when the profits were distributed. In the situation, the cross-border situation, the foreign subsidiary, if it used up reliefs and loss relief, etc., and then paid the dividend to its parent, that dividend was taxed at the full rate of corporation tax. And therefore, the reliefs, in a sense, that the foreign subsidiary had used were lost. Indeed, it was worse than that, because the reliefs would have reduced the amount of foreign tax they paid, and therefore the amount of double tax credit that they would have received. So take an extreme case, if the foreign subsidiary had made 100 of profits, but had loss relief, which covered the entire profits and paid no corporation tax, and then paid the 100 up to its UK parent, it would pay corporation tax let's say 35% on that, with no relief, because there was no foreign tax, in fact, paid on the profits. So that was the simple distinction. As regards ACT, the point was this: if you compare a UK to UK situation, where ACT was paid by the subsidiary, the parent received franked investment income. A dividend paid by a foreign subsidiary to a UK parent could never carry franked investment income. And therefore the onward dividend would be charged to ACT. Whereas in the UK situation, the onward dividend would not be charged to ACT because of the franked investment income credit. And that was said to be a difference in treatment, which was contrary to the treaty. And you find this in the original particulars of claim. You can find it in the BAT particulars of claim, for instance, which is in the appendix. It's in part 2 of the appendix. It's page 1041 of the appendix, MS 5086. And it's paragraph 14, which begins at the bottom of the page, which summarises the difference in treatment. And you'll see that sets out pretty much what I've been saying broadly as being the difference in treatment. And the consequence of that is set out in paragraph 17. Because of that difference in treatment, they provide a disincentive for UK companies to establish subsidiaries on the member states or to move capital. So that's why it is prima facie a restriction on freedom of establishment and capital movements. Now this led to, as I mentioned earlier, some of the corporation tax and some of the ACT being charged unlawfully. Now, the computation of that unlawful ACT and unlawful corporation tax was complex, and I think those of you who were involved in the permission hearing will have heard something about the many issues that arose in computing the unlawful tax and deciding which tax was unlawful and when it was paid, and then, as I say, when it was surrendered and when it was set off. But whatever the answer to that computation, the basis of the claims in mistake is that the amounts which were charged unlawfully, whatever they turn out to be, were paid through a mistake of law. Now, this litigation has been going on for quite some time. The claim forms were originally issued in 2003. The first stage was not any kind of trial or lengthy hearing, but was a reference by Mr. Justice Park on essentially very sketchy facts. I mean, the only facts I think that we set out were that dividends were paid and the ACT and corporation tax were charged. So if you looked at the order for reference, you would see most of it is taken up with the UK tax system and explaining how it worked. And the only facts that were needed were that dividends were paid, and we knew that there were dividends that had been paid. It was based on that, because at that stage we wanted to discover whether this was unlawful and to what extent. So there was a reference made. This is the first, what we call the first reference, and that's the result of that was a judgment in 2006. Quite a long judgment for the European Court. There were quite a number of issues relating to both the incompatibility of the provisions with the treaty, but also the consequences for remedies. There were questions about sufficiently serious breach in relation to damages claims under European law, and questions about San Giorgio and what sort of claims might qualify as San Giorgio claims. Now, some of that, for reasons that I'm going to explain, some of that may come before this court in December, in the next hearing. Because what then happened was, after the reference, there was a hearing in 2008 before Mr. Justice Henderson, who had by that time become the nominated judge. And that was, although it was not in form a trial of preliminary issues, in substance that's what it was. I think Mr. Justice Henderson himself said in the course of his judgment that these were discrete legal points that he was being asked to decide, which arose from the reference. And even at that stage, he was able to answer them on fairly limited factual findings. So there were a whole host of legal questions, and you will have seen that, which were decided by Mr. Justice Henderson. There was then an appeal to the Court of Appeal, and all these questions were again aired, and the Court of Appeal upheld some of his decisions and reversed some of his decisions. Most importantly, possibly for our purposes, was the question of the validity of two statutory provisions that had been introduced to deal with the limitation problem, which was Section 320 of the Finance Act 2004 and Section 107 of the, I think, 2007 Finance Act. Mr. Justice Henderson, one of the issues at this stage was the validity under European law of those provisions. Because on the face of it, those provisions removed the extended limitation period under Section 32(1)(c) of the Limitation Act in relation to tax claims. So it had provided essentially that the limitation period for claims of mistake of law and tax was 6 years, full stop. Mr. Justice Henderson held that those provisions were contrary to European law, but that was reversed by the Court of Appeal, who held that they were valid and were not incompatible. And that was one of the issues for which permission was sought to come to the Supreme Court. I think it's right to say that both sides sought permission on every issue at that stage. What happened then was that the Supreme Court decided that they would first of all refuse permission in relation to a number of issues where the courts below had decided to make a reference to the European Court. The effect of that being that the reference would then go ahead. And that is the second, what we call the second reference. They then gave permission on a number of issues, including the Section 320 and 107 issue, and some other related issues. And that resulted in the hearing, and we have you'll have seen the judgment. I think my Lord Reid was the only one.
I think I'm the only survivor
who survived. The result of that was this court decided that Section 107 was contrary to European law, Act Clare, but Section 320 was referred. The question of the validity of Section 320 was referred to the European Court by this court, and that is what we call the third reference. And in that reference, of course, we now know that the court decided that Section 320 was contrary to European law as well, insofar as it took away existing rights. It's perfectly valid for the future, and it's still in force, in fact. But it couldn't have the effect of removing vested rights. There is still some litigation on 320. I might come back to that, but it's one of the points raised by the respondents. The other thing which the Supreme Court did at that stage was to defer consideration of a number of other issues which had come from the Court of Appeal, pending developments. I think they were thinking particularly at that stage of Littlewoods, but also possibly Prudential subsequently. So that there are a number of issues from the first Court of Appeal decision that are still under appeal and haven't been determined, and some of those issues are going to be, well, set to be heard in December. So the reference came back, the second reference came back, and the third reference. And at that stage, there was a further, well, at that stage, the parties considered what they were going to do, because we'd had an answer to a lot of legal issues, but there were still issues that arose, particularly about the computation, the difficult computation issues, but there were a number of other issues which still hadn't been decided. So the decision was taken that the best way forward would be to try the BAT claim, because the BAT claim was very, very large, and it went back to 1973, and it looked as though it raised all of the, or as many of the issues as we could see. So by trying that case, these issues would be determined. That proved not quite to be right, and two other test claimants had to be added for smaller issues within that. One of them is Ford, and that case is still under appeal. That's one of the cases that's under appeal in December. And we may come back to that later. But that resulted in a hearing before Mr. Justice Henderson in 2014, when he decided a lot of other issues. You'll have seen those, and that was subject to an appeal to the Court of Appeal. And this particular issue, issue 28, was one of the issues decided by Mr. Justice Henderson and then appealed to the Court of Appeal in the second stage. After the Court of Appeal decision, permission applications were made, and this court has determined them, along with the permission applications that were held over from the previous Court of Appeal. And that has resulted in an overall permission decision, which is the order that was made most recently, allowing permission on certain issues. And this is one of them. The others are, as I say, at the moment due to be heard in December. So the first question, I think, which arises before I move on to the substance, what I was proposing to do briefly was to look at the question of jurisdiction, but look at it as a hard-edged question, not a question of abuse or discretion, but a question of whether there is jurisdiction to hear the appeal, and whether the issue has actually been decided previously, because that would be, again, a hard-edged reason why it couldn't be decided again. After that, I was proposing to move to the substance and deal, subject to what the court feels is most convenient, with how Section 32(1)(c) should be construed, assuming it applies, is capable of applying to mistakes of law, and then subsequently dealing with the issue which the court indicated it would like submissions on, which is, should it in fact be construed to apply to mistakes of law at all. And then finally, I will address the arguments which have been put under the portmanteau heading of Henderson, Virgin, pleadings, New Point, etc., whatever exactly they are. So if I could deal then first with the jurisdiction question. And I would submit it's really quite straightforward. Appeals lie to the Supreme Court from, amongst other things, orders of the Court of Appeal of England and Wales. The relevant order for present purposes is an order of the Court of Appeal of the 5th of December 2016 or 24th November 2016. It's not really, never clear which exactly is the correct date, but anyway. It's paragraph 3, little Roman 3, and you'll find that in the core volume 2. And it's MS 4048. It's page, well, the order begins on page 2, and then it's on page 2, paragraph 3, little Roman 3. Declaration 24A, that's a declaration in the order of Mr. Justice Henderson, is amended to read: the date when the claimants discovered or could with reasonable diligence have discovered their mistake is 12th December 2006. 12th December 2006 was the date on which the Court of Justice gave judgment in the first reference. And the issue you can see set out on page 6, MS 4051, issue 28. When did the claimants discover, or when could they with reasonable diligence have discovered their mistakes? The real issue is when they could with reasonable diligence have discovered their mistake. It's accepted as a matter of fact that the claimants subjectively actually discovered their mistake at a time in which they would be within time. However, it is necessary in order to determine what the could with reasonable diligence provision means, to consider what it means to discover a mistake at all. And the Court of Appeal dealt with this. It's in the same volume, page 102 to 103, 4147. The Court of Appeal dealt with this by applying the principles which it derived from DMG. They said in the paragraph 372, correct starting point must be the reasoning of the majority in DMG, which was concerned directly with the issue of when a mistake of law can be regarded as discoverable. In our view, quite clear that the majority held that in the case of a point of law which is being actively disputed in current litigation, the true position is only discoverable for the purposes of 32(1)(c when the point has been authoritatively resolved by a final court. That's explicit in the speeches of Lord Hoffman and Lord Hope. And although I argued that Lord Water's reasoning was different, they held that it wasn't. Now, as with any issue which comes before the Supreme Court, the court must determine this court must determine what the correct legal principles are before applying them to the circumstances of the case. And so, on this appeal, this court is being asked to determine what those legal principles ought to be. And in other words, was the Court of Appeal correct in the principles it set out? Or will this court depart from the decision in DMG and say that wasn't a correct interpretation of Section 32(1)(c)? So that's how this issue arises on issue 28. If I could just look at the different groups within the claimant, within the GLO and outside it, you can divide them into 4 categories, I would submit. There are 9 claimant groups. We think there are 9, but different numbers have been given, who are members of the GLO and who brought their claims after March 2007. Now, on any view you take of this, the decisions and appeals on issue 28 have always been relevant in respect of those claimant groups. Mr. Justice Henderson's decision left them with no claims beyond 6 years, because the effect of his decision was that they'd brought their claims more than 6 years after the date of discoverability. And they are dealt with in the Court of Appeal judgment at paragraph 349, which is on page 93, MS 4138. Where they make the point about the re-amended defence, and then they say, however, some of the claimants in the FII group did not initiate proceedings until after 8th March 2007, and HMRC in due course made it plain that although pleadings had not been required in the cases of those claimants, it would be raising a limitation defence in them. Although we're not given details, it appears there are about half a dozen claimants or groups. I think, as I say, I think there are actually 9. So there is no doubt that at all times the limitation issue has been in play, whatever view you take of what was said below in relation to these claimants. As we understand it, the respondent's position appears to be that the court must decide whether to overturn the decision of the Court of Appeal, but without questioning DMG. That is to say, whatever you think about DMG and about Clement Benson, you must apply it to these claimant groups. There are also 9 claimant groups who have FII-type claims brought after March 2007, but who are not, for some reason or other, part of the GLO. They somehow have not...
Is this story, we've got 4 groups?
This is the second one.
This is the second group.
This is the second one, my lord, yes. The first one was the 9 groups who are members of the GLO who brought their claims after 2007. The second one is the 9 claimant groups who are in the same position as them, but are not in the GLO formally. But their claims will have to be adjudicated on the basis of the law, we would say, as declared by this court. The third group is the...
They stand or fall with group 1.
With one, we would, yes. But I'm just pointing out that there are more groups than the 9 in the GLO who are affected by this. Then the third is the back group itself, just the back group, because it has had its claims tried, it's had pleadings and an agreed position at trial. And the back group has an argument, whatever you decide the law to be, it doesn't apply to its claim. And in the fourth group are the 21 claimant groups in the GLO who brought claims before March 2007. They haven't had any pleadings. If I can just pause there, the reason that there haven't been any, when I say pleadings, there haven't been any defences in any of these cases apart from bad, is because one of the terms of the GLO is that when someone joins it, their claims are automatically stayed. And so it's not necessary for any further steps to be taken in the litigation after they bring their claims and file their particulars of claim. So we have large numbers of claimants who have simply filed a claim and then their claims have been stayed. Nothing further has been done. And there are 21, as I say, other groups in the GLO in that position. And we say that they would be bound by any decision on issue 28 under the normal terms of the CPR on GLOs, and there's no reason to release them from that effect. Perhaps while I'm dealing with those who are affected, I might just mention other areas which are affected by this. There are other historic tax claims, i.e. claims that go back many years. In particular, there is something which is called the FID GLO. That GLO was started at about the same time as the FII GLO. It concerns the shareholders who didn't receive a tax credit because their dividends were FIDs. It's one of the features of the FID regime that the recipient of the dividend didn't receive a tax credit. And they're claiming that they ought to have received a tax credit as a matter of European law. There are also within that group now claims which are called Mannanen claims, which are also claims by companies who received dividends and didn't receive tax credits. Again, are claiming they should have received tax credits. That GLO was stayed in about 2005 by Mr. Justice Park, because at that stage it was said that they ought to be taking proceedings through the tax appeal mechanism. And there was also, at that particular stage, we were in the position where DMG had been decided in the Court of Appeal and that they didn't have any claims in mistake, according to DMG. So it was a particular point in time when it was stayed. They were stayed, and the claimants, since then, they've been pursuing the statutory procedure. And there have been court proceedings, there's been appeals all the way to the Court of Appeal several times, I think, on this issue. But the result was that most of the claims were out of time under the statutory procedure. And so what's now happened is that they are reactivating the GLO and claiming that they're entitled to claim under mistake in 32(1)(c). I understand those proceedings have been paused, if not stayed, pending the resolution of this issue from this hearing. There are very large sums at stake in the FID GLO, running into a number of billions of pounds. There is also something that a GLO relating to stamp duty reserve tax, and there's a case called Jazztel, which was decided in relation to that. You may have seen mentioned in some of the papers. It's called Jazztel. I think it's Jazztel. A decision of Mr. Justice Marcus Smith. That GLO will also be affected. I say this because one of the points that the respondents make in respect of, I think, the practice direction and whether you should actually decide to reconsider and overrule previous decisions, is that this is a purely historic matter. As far as tax is concerned, certainly direct tax, that is true to some extent. There are provisions that have been introduced in about 2010 which mirror the VAT provisions, which have said that you can only recover tax through the statutory procedure, not by any other means. Now, those provisions themselves are being challenged. There is a case, it's Class 8 of the CFC GLO, and we've had already a decision from the Chancellor about that. But in principle, in the future, there shouldn't be such problems. But as your Lordships were well aware, Section 32(1)(c applies generally. We've had Climate Benson, we've had the problems with unlawful contracts by local authorities, but we don't know no one knows what the next commercial scandal is going to be that's going to result in litigation like that. So, and whether one can recover under Section 32(1)(c for mistake of law could be a very important issue in claims that might arise in the future. So it is, we would suggest, an important point both for ongoing litigation and for potential future litigation. I then turn to the question, so I would say clearly there is jurisdiction to hear the appeal and to decide the issue. I then turn to the question of has res judicata in the strict sense, has the question been determined in these proceedings? And the answer to that we would say is clearly no. And I don't think, to be fair, that the respondents actually say it has been decided. But they themselves asserted in their Court of Appeal skeletons in these proceedings that it hadn't been decided. You'll find that in Appendix 2 at MS 5709. It's paragraph 99. This is
what?
This is the respondents, their skeleton before the Court of Appeal below.
Paragraph.
It's paragraph 99. And it's dealing with Mr. Justice Henderson's decision that the date was 2001. So in reaching a contrary conclusion, the judge was influenced by passages of Lord Walker's speech in FIISC and the judgment in 3. Lord Walker was not, however, addressing the date of constructive discovery, which was not an issue in the appeal, but the very different question, in the context of Section 320 and 107, whether the FII claimants had a legitimate expectation they'd have time to bring their claims in accordance with existing time limits. And moreover, it's just a recital of the key events. So, and that we would say that the claimants are right about that. This wasn't an issue the first time round. And of course, a reason that it wasn't an issue, if I just might say this, is at that stage, there was primary legislation which had removed the extended limitation period in 32(1)(c. And the focus of everyone's attention at that time was that legislation valid? So the litigation went on the basis that there was this legislation, but it might be struck down. Can I then turn to the substantive issue?
Just before you do,
Yeah.
Mr. You may be going to return to this when you get to the point the court asked you to deal with. The formulation of issue 28 at page 4051 assumes an answer to the issue the court raised, namely that section 32(1)(c) does apply to mistakes of law, and therefore the order was resolving an issue within that straitjacket, you might say. Is there any separate jurisdiction point that you want to deal with about that further question, or are you going to defer that until you get to it?
Can I? Yes, I will deal with that when I get to the...
Okay, just as long as it doesn't get missed.
Yes. Can I then clarify two things, what the revenue are not doing? I hope this is obvious on this appeal. We're not challenging the existence of a claim in unjust enrichment based on mistake of law. In other words, we're not challenging in any way the lifting of the mistake of law bar. Although we do question, and you've seen in relation to some of the arguments, what is a mistake for this purpose? And we're equally not challenging the existence of such a claim to recover tax mistakenly paid. Certainly at the time that we're dealing with. As I say, there have been developments since then, which mean that in most tax cases you wouldn't be able to claim. You wouldn't be able to make a common law claim now. But in the period that we're dealing with, it was possible. So we're not, these were the central issues in Claimant Benson and in DMG respectively. In Claimant Benson, the central issue was, should we lift the bar, the mistake of law bar, which had been around for centuries and was accepted to be part of the law prior to Claimant Benson. And in DMG, the question was, well, does that apply to tax claims? Or is there something different about tax? We're now in the position that there isn't anything different about tax. But that was undoubtedly what DMG was mainly about. The respondents complain that the revenues arguments in this case lead to section 32(1)(c) having no role. This is, of course, is before we get to the question of whether it applies at all to mistakes of law. But even our arguments on the application of 32(1)(c), they say it has no role. Obviously, this is wrong, first of all, because it clearly applies to mistakes of fact. So the provision has a role, its original role, its original design role, whatever you decide about mistakes of law. And a linked point to that there's no reason to assume prima facie that 32(1)(c) need have any practical effect on claims based on mistake of law. And that's simply the point that was made in Claimant Benson, been made a number of times since. When 32(1)(c) was introduced first in 1939, and even when it was consolidated in 1980, the law was understood to be that claims based on mistake of law did not exist. So it's not a surprising consequence that the application of a provision that wasn't designed for mistakes of law should not have any practical effect when you apply it to mistakes of law. Now, 32(1)(c) is a limitation provision. The date which is derived from the application of section 32(1)(c) is not, this is very important, I think, it's not the date on which the claimant must prove its case. It's not even the date on which the claimant has to bring its claim. It has 6 years from that date to bring its claim. It is a date on which it is, we would say, in a position to start investigating whether it has a worthwhile claim. And that, as you will have seen, is what has been decided in all of the other Limitation Act contexts where knowledge or discovery is relevant. I'm going to come back to that, but you will have seen the provisions on personal injury, the provisions on discovering fraud, discovering concealment, etc. None of those cases has it been said that you have to wait until you can actually prove your case before the limitation period starts. And I think this is something that perhaps is often sometimes forgotten in this context, that we're not talking about the time at which the claimant actually has to show they made a mistake in court. It's a much earlier stage than that. And that's why we would submit the cases on limitation have been decided the way they have. Can I then next take you, what I was proposing to do next was to take you to Claimants, Benson and DMG, because these are the critical authorities, and summarise what we say about them. Claimants Benson is in the First Authorities Bundle, tab 15. The first judgment is given by, in order, is given by Lord Brown Wilkinson. Of course, this is one of the dissenting judgments. And Lord Brown Wilkinson's concern seems to have been mainly about the position where there was a binding decision previously, let's say by the House of Lords. Individuals or companies acted on the basis of that, made payments on the basis of the law set down by that decision. And then subsequently, it was overturned by a subsequent decision, let's say of the House of Lords as well.
He was mainly thinking about previous decisions of the Court of Appeal, as I recall.
Maybe Court of Appeal, yes, but whatever. Anyway, there was a decision so that everybody would say that was the law as it stood then. And then subsequently it was overturned, maybe many years later. I guess Spectrum, there was a case called Spectrum, I think, in this court.
Respectrum Plus.
Spectrum Plus, where something similar, although I think the original decision was a first instance decision as it happened, but it had been followed ever since and thought to be the law until it was overturned. And I'm sure there are other examples, but that, we would suggest that that is actually a much rarer case than the more normal case, which is our case, which is where nobody's really thought about the position. There hasn't been any decision previously. There isn't any settled law in the sense that anyone's actually given it consideration and decided what the law is. But at some point in time, someone decides to challenge it or to decide what the law is, to find out what the law is, if you like, or to make a claim.
Law classification, those are categories 2 and 3.
Yeah, exactly.
Lord Brown Wilkinson is category 2, what you're now describing is category 3.
Yes,
Yes.
exactly. But it does look as though he was very concerned about that. I think the other problem when reading Claimants Benson is that, as you will well know, it went to the House of Lords by a leapfrog from the first instance judge. There was no real trial. He simply decided the issue against the preliminary issue against the claimants on the basis he was bound by previous authority, and gave permission for there to be a leapfrog to the House of Lords to consider it. That meant that there were no findings of fact, and it hadn't been decided in Claimants Benson whether there was a settled view of the law. You'll see settled law discussed, and it's sometimes discussed as a defence, and it's sometimes discussed in the context of whether there actually was a mistake. But in either case, it hadn't been decided. And so the problem was, if settled law was relevant, the matter would have had to go back to the first instance judge, I think, to decide whether there was any settled law or whether this was just a case where nobody had thought about it before. Which it does rather look as though was the case, as far as I can see from the facts. It was simply a case that nobody had really thought about it much. But anyway, what Lord Brown Wilkinson is very concerned about, though, is this actual hard-edged situation where there was a decision, people relied on it, and made payments, and then it was reversed. And the question was, did they make a mistake? And he was very doubtful as to whether somebody made a mistake in those circumstances, because they made a payment on the basis of what the law was. So at the time they made the payment, there wasn't any mistake. His conclusion, I think he says that if you look at the bottom of, page 363, MS 500, just below G, he says, I can see nothing unjust in permitting the payment to retain monies he received at a time when all lawyers skilled in the field would have advised that he was entitled to receive them and the payer was bound to pay them. Again, it's critical to establish a position at the time of payment. If at that date there was nothing unjust or unmeritorious in the receipt or retention of the monies by the payee, it's not an unjust enrichment for him subsequently to retain the monies just because the law in one sense subsequently changed. That was his view. He agreed that the problem he had was he agreed that the mistake of law bar should be removed. And you can see that on page 364. Just below the last paragraph below letter D. In my law, in those circumstances, I find myself in a quandary. Convinced that the law should be changed so as to permit monies paid under a mistake of law to be recovered, I also accept for the reasons given by Lord Gough, the relevant limitation period should be 31C, 6 years from the date where it could be discovered. The majority of your lordships consider such claims will arise when the law, whether settled by existing authority or by common consensus, is changed by a later decision of the courts. He thought that was wrong, and therefore he decided, perhaps slightly surprisingly, that because of that, he would dissent and he would have dismissed the appeal. He would have left the entire thing to Parliament. That was his position. Although he thought that the bar should be lifted in certain cases, he wasn't prepared to say that, where it wouldn't be lifted in other cases. He wasn't prepared to agree with the majority, so he decided he would simply say it shouldn't be lifted at all. Now, what we do know is that the result of the decision of the majority was that the claims succeeded, and there was no need to remit the matter back to the first instance judge. What's not 100% clear is whether that was because, when you look at each of the judgments, whether that was because they believed that whether there was a settled law or not didn't matter, or whether they believed that there wasn't a settled law in that particular case. I think it's clear that Lord Hoffman, we get to that, thought it didn't matter. He thought any mistake, whether it's a deemed mistake, you call it, or an actual mistake, was sufficient. Lord Gough is more difficult to tell with Lord Gough. Because he simply says, if we look at page 375, conclusion.
What's the electronic page?
Sorry, it's MS 512. He concludes that the mistake of law rule should no longer be maintained as part of English law. That's just at letter H. And English law should now recognise there is a general right of recovering money paid under a mistake of fact or law, subject to the defences available in the law of restitution. And he goes on then to consider payments made under a settled understanding of the law.
Sorry, where are you now?
He goes on to consider that beginning on page 376, which he regards as the central question in the appeal. And his conclusion...
That's the fact that they're made under contract, understood to be valid and binding at the time.
Yes.
So that's a settled law.
Yes. He deals with the declaratory theory, because that's all part of this argument. At the bottom of page 378 and the top of page 379, that's MS 515, 516. He sees it as simply being a feature of any legal system, that if a judge makes a decision, it applies to the case itself retrospectively, in a sense, because it applies to facts that have occurred in the past, and it has to equally apply to all other cases which happened in the past as well. And he says that simply is how a system has to work. So in a sense, it's a kind of policy justification. He's not saying there's any. It's not based on any declaratory theory or any fairy tales. It's simply that is how legal systems have to work.
Where is that?
In practice, it's page 3, the bottom of page 378. The paragraph beginning, "It is in this context we have to reinterpret the declaratory theory," and it goes on to page 379. At the top of that, he says it's inevitable in relation to the particular case before the court, in which the events must have occurred sometime, perhaps years before the judge's decision is made. But it's also inevitable in relation to other cases in which the law is so stated will in future be applied. I must confess that I cannot imagine how a common law system, or indeed any legal system, can operate otherwise if the law is applied equally to all and yet be capable of organic change. That's the view reached by in Cross and Harris. And then at the bottom of that paragraph, he then you can see he says, I regard it as an inevitable attribute of judicial decision-making. Some such theory must, I imagine, be applied in civil law countries as in common law countries. I understand the declaratory theory applies in Germany. So he regards this as simply being the way that the system has to work. And he goes on to then conclude at the bottom of that page, was the bank mistaken? In the light of the foregoing, I have to ask myself whether the Law Commission's settled understanding of the law proposals form part of the common law. This, as I understand the position, requires that I should consider whether parties in the position of the appellant bank were mistaken when they paid money to local authorities under interest rate swaps agreements, which they, like others, understood to be valid, but have later been held to be void. Well, he says they understood it to be valid, but it's not really very clear whether he's saying there was a strong, settled understanding of the law. To me, it's plain the money was indeed paid under a mistake, the mistake being a mistake of law. The payer believed when he paid the money that he was bound to pay it. He's now told that on the law as held to be applicable at the date of the payment, he was not bound to pay it. Plainly, therefore, he paid the money under a mistake of law, accordingly subject to any applicable defences he's entitled to recover. So he thought he was dealing with a situation where the law as applicable at the date of the payment was that he was not bound to pay it. What's not clear is whether he means by that the sort of deemed to be applicable situation, or whether he's just straightforwardly saying this is a case where, all right, they understood that they had to pay, otherwise it wouldn't have been a mistake. But we now know that the law at that time was that they didn't have to pay. It's not a question of the law changing, it's just that was the law then. It hadn't been revealed, it hadn't been decided in a case, but that was the law. It's just not, it's not at all clear because he didn't have to then remit the case back. Now, it may be that he is saying, I don't know how it's possible to tell, but it may be that he was thinking all mistakes of the type where there's a judicial decision changing the law or overruling the law, whatever, are also mistakes. You also make a mistake then, but he certainly doesn't expressly say so. He considers a number of other defences that aren't relevant to these proceedings, honest receipt, etc., and whether they should apply the Law Commission proposals. And then he goes on to deal with section 32(1)(c) itself. Does it apply? Now, I was going to come back to this when we deal with the issue. You'll see he made some written submissions on this. But his conclusion is that 32(1)(c) did apply to mistakes of law. But essentially because he didn't accept the submissions that had been put about the historical position. And he relied on two cases in particular, you'll see, Inri Diplock and Philip Higgins. And we would say neither of those cases support what Lord Gough said. Philip Higgins was simply about something else. And the passage in Inri Diplock, I'm going to take you to that. But in fact, when you look at the way that Lord Green decided the case in Inri Diplock, you'll see that actually he wasn't saying at all that there are claims in mistake of law and equity. Indeed, he seems to be saying the opposite. These claims didn't exist, but if they did exist, they would be a limitation answer. That's what he was saying essentially. But I'll take you to Diplock.
If I'm missing something obvious, I'm finding it a little puzzling reading this. This is a case of a payment made under a contract. The contract is void. There's nothing very surprising about the recoverability of a payment made under a void contract.
Yes, and they would have been able to recover it as, I think what they call money hadn't received or something like that. Yeah. But they would have a 6-year limitation period.
Yes, I mean, one wonders why. I mean, unless they were just determined to deal with mistake of law, you wonder why put it into that pigeonhole and analyse it in that way.
If they had to claim under mistake to get a longer limitation period, otherwise the claims, there were claims that were
more than 6
years.
So it's all driven by the
yes,
sorry.
That was the main battle in DMG as well, no doubt.
Sorry?
That was the main issue in DMG.
Oh, that's why DMG, yes, exactly, yes, of course. That's why all of these, it is a slight oddity of these cases.
Yes, because the problem about the contract was that, I mean, sometimes contracts are void because they're made under a mistake, but the problem here wasn't, it wasn't vitiated for that reason, it was vitiated because it was ultra vires.
No, exactly. And similarly, in our case, the reason that they didn't have to pay was because the obligation was unlawful. And there's no doubt that they have a claim in what we call willage to recover it, but that doesn't get them beyond 6 years. So, yes, I mean, it's quite explicit in this case that the reason why they're bringing it is because some of the payments are beyond 6 years.
I see. Yeah.
So, yes, that's the whole point. But the odd thing is that in this case, and in DMG, actually to some extent, the central issue really ought to have been 32(1)(c), because that was what it was all about. Yeah. But in fact, the central issue became, possibly because lawyers find it more interesting, in this case became the question about mistake bar and settled law. And in DMG, the central issue became, did what Lord Gough said apply to tax? And of course, in DMG, the Court of Appeal held it didn't apply to tax, having looked at what Lord Gough said in this case and in Woolwich. But anyway, in both cases, the 32(1)(c) issue was not central to the argument. And so, hopefully in this case,
so you ignore the fact that the contract is void because it was ultra vires. You focus on the fact that there was a mistake affecting one of the parties in performing the contract or entering into it. And the mistake isn't bad enough to render the contract a nullity, apparently. Nobody suggests that. But it nevertheless...
The mistake was you made the payment.
nevertheless
simple
gives
as
rise to a
that.
restitutionary
You
claim
wouldn't have paid.
without invalidating the contract.
Yes, but you wouldn't have paid in Claimant Benson. They wouldn't have paid had they known the true state of the affairs. And similarly, in our case, they wouldn't have paid the tax had they known that it wasn't due and they didn't have to pay it.
The true state of affairs in Claimant Benson was that the contract was void.
Yes.
Yeah.
Well, that's right. Yes, the true state of affairs.
Which,
Depending how you get there, but certainly the true state of affairs, it having been decided in the Hammersmith case,
yeah.
that it was ultra vires, the local authorities, to enter into the contract. Then the contracts were void.
So you say, the mistake I made was I didn't realise I was entering into a void contract, effectively. But I don't want to get my money back on the basis that I have a claim to restitution on that basis. I want to say that because I made a mistake in entering into a void contract, I have an extended limitation period in claiming on that basis.
Yes.
Is it a mistake entering into the contract or a mistake making a payment under the contract
it's a
after you've
mistake
entered
making
into
a
it,
payment.
under the mistaken belief that it's a valid and binding contract?
Yes, under the mistaken belief that you were obliged to make the payment legally. So you wouldn't have made the payment if you knew that you weren't liable to make it. And this comes from the English, I don't know whether it's the same in Scotland, the English principle that you have a choice of actions.
Oh, yes,
as
yes,
Lord
yes,
Hope said.
yeah.
So,
Yes, no, I mean, what's striking is that a unilateral mistake, which is seen here as grounding not the, resulting not in the invalidity of the contract, but in a claim to restitution because of a unilateral mistake.
yes, yeah, and we know that in unjust enrichment, it doesn't matter about whether the claimant was culpable in any way, negligent or whatever. If they made a mistake subjectively, then they can recover. It's quite a generous doctrine in that respect.
The Law Commission proposal, which they're referring to there, is the one going back to the 1994.
Yes, yes. It's not the 2001.
No, it's not something which I...
That was afterwards.
Nothing to do with me.
Yes.
None the worse for that. But we don't have it with the particular passage, do we, of the...
I'm not sure.
This is, I mean, I see it's referred to on
Yes.
page MS
But
509.
I think I think it's set out somewhere.
Yes,
It's a proposal that settled law should be part of the.
The legislative proposed change is actually quoted somewhere. I can't
Quoted some, yes, it's quoted in the case, and it was that you wouldn't be able to recover if it was settled law and it was defined in certain ways.
I don't think that was then picked up again in our 2001 report.
No, I don't think so. Possibly because it was sort of criticised a bit in this case. I think said.
I think we probably
Yes.
we took that as a sort of base, but
Yes.
I
Yeah.
don't know. Has anyone looked at the consultation paper on the preceding the 2001 report?
Yes, I think we are. Yeah, the 2001. That was the proposal that there should be a 3-year period, but extendable, but with a 10-year
10-year, yes.
backstop. Yeah.
I wondered whether there's anything in the consultation paper which discusses this, but I suspect not. I don't have any recollection.
Well, 528 to 529, electronic.
Okay, thank you. Mr. Ensign says he's read it but can't remember.
I read it, presumably, at the time.
No. Sorry, I wasn't proposing to look at this passage 132.1c in detail now because I was going to come back to it when we look at the question of whether 32.1c would apply to mistakes of law. We then turned on to, so Lord Lloyd was also one of the dissentients. He accepted that the mistake of law bar should be lifted as well, as did everyone. He considered payments made under a settled view of the law were not made under a mistake of law, even if the law subsequently was changed. And he would have remitted the case to the High Court to determine whether the law was settled. But obviously that was a minority view. Lord Hoffman now he didn't differentiate expressly, I think, between cases where the law was settled or decided previously and cases where it wasn't. And he deals with it particularly when he talks about the imaginary client and lawyer. This is on pages, beginning on page 399, MS 536. Where the client was asking why he couldn't recover his money when he had now been told by the courts that it wasn't due. And he says, he concludes at 399F, below F, one must therefore ask why, in the context of unjust enrichment, this should make a difference. In both cases, it's turned out the state of affairs at the time was not, or was deemed not to have been, what the payer thought. In the case of a mistake of fact, it is because things were actually not what he believed them to be. In the case of a mistake of law, it is by virtue of the retrospectivity of the decision. Does the principle of unjust enrichment require this retrospectivity should be carried through into the question of whether the payer made a mistake? In my view, it would be very anomalous if it did not. And then he imagines a client who consulted a lawyer but seeks advice after the House of Lords, which decides the obligation was void. The lawyer tells him that the House of Lords has said he doesn't have to pay. He says, can I recover my money? And the lawyer says, no, because if you had consulted me at the time, I would have told you you were certainly right to pay, therefore you made no mistake. Does that mean the obligation was actually valid? If so, what has made it invalid then? The lawyer has to answer no. House of Lords has told us that it was always void. Nevertheless, you made no mistake. And then he goes on in the next paragraph, my lords, it seems to me that the imaginary client would have great difficulty in understanding how these distinctions can arise out of a rule giving a remedy for unjust enrichment. In each case, he thought that the obligation was valid and it subsequently turned out it was not. In principle, the question should not turn upon what other people might have thought what the law was, but upon what he thought the law was. What he thought was the law. And this has turned out to be wrong, however many lawyers might have agreed with him at the time. So there ought to be a remedy in all cases or none. I should mention that Mr. Southall said in his written submissions in reply that if someone made a payment because he'd been told that the Court of Appeal had decided that a person in such circumstances should do so, he would not be treated as having made a mistake when the decision was subsequently reversed. But he thought that the answer would be different if he had not been told of the decision but came to the same conclusion on first principles by accident. He commented that this was an absurdity which might be thought to cast doubt upon the soundness of the proposition. I think it's wrong. It doesn't matter why the payer thought the law was requiring him to pay. Retention is prima facie unjust if he paid because he thought he was obliged to do so, and it subsequently turns out that he was not. So I think Lord Hoffman's very clear of what he thinks the position to be. Although, of course, he began the speech, I think, by saying
Changed his mind.
that he changed his mind. Yes.
Well, what's interesting for our purposes in relation to section 32 is perhaps what he says just above letter F on 399, where he accepts, I think, as he puts it, that in principle, and leaving aside the problem of Schrödinger's cat, the truth or falsity of any proposition of existing fact could have been ascertained at the time, whereas the laws that would subsequently be declared to have been could not. So
Yes.
there's a difference in relation to what we've been calling discoverability.
Yes. But of course, that's if you're asking if the question you're asking is, can I discover what the law actually is? For sure. But that's not what we would say the question is that you're asking. Because you would only be asking that question at the point when you're actually proving your case. I mean, this is the difference that has emerged between say personal injury cases, where claimants are out of time even though they can't prove their case at that point. They've been held to be out of time. But in this case, if this is right, if DMG is right, claimants in mistake of law can never be out of time until they could prove their case for sure, because the ultimate court has told them that they made a mistake, that the law was actually Y. And that's quite a striking difference between the two positions.
Is it so much that the statement is final, whereas previously there was debate, or rather that because it has retrospective effect, that really is what makes the difference? It recreates what the position was at an earlier stage, when at that earlier time it wasn't.
That's one of the differences between law and fact. Facts don't change, despite what Lord Hope says. The fact at the date of payment are the facts. You may not be able to determine them for a number of years after that, what they were, but the facts don't change. If the question is, was somebody, for instance, was somebody your son at the time? He either was or he wasn't. I mean, it may be that you can't determine that question until DNA testing comes about or whatever, for sure, but the fact doesn't change. And you're right, my lord, the law does change in a sense. But the other, though, important difference between law and fact is that facts can be hidden. There can be a situation commonly where facts cannot be discovered. Whereas law, in principle, is not hidden. The law is there. It's available to everyone. There's nothing private in the law. It may require someone to analyse it, to look at it, but all the materials are there. And that's important, I think, when we come to look at the questions of limitation. So, as I say, Lord Hoffman, definitely in the camp of all mistakes, deemed or otherwise. And then we turn to Lord Hope, finally. Now, Lord Hoffman didn't say anything separate about 32.1c.
I'm sorry, it just caught my eye. I don't know, did you take us to the passage on 401 between D and E?
I didn't, although I have got it marked here, so it obviously must be an important passage. Yes.
Well, it's
yes,
the second sentence.
Yes. Yes, I think a number of them say something similar to that. That's assuming that the Limitation Act means what they think it means. I think it's his point being that you would only discover the mistake potentially years later. So Lord Hope, I just point to one passage at page 403, MS 540, under the heading the facts. The points of claim state the payments were made by the bank on the basis of mistaken belief that they were being made pursuant to a binding contract. No details are given of the circumstances or nature of the alleged mistake, and there have been no requests for further and better particulars. The pleadings appear to have been framed on the assumption that there was no issue as to whether or not the bank was acting under a mistake when it made the payments, the only issue being whether the mistake was a mistake of law. He then says on the facts at the bottom of 404H, it appears at the time when the transactions in the present case were entered into, there was a general understanding which was shared by banks and local authorities as regular participants in the money markets that interest rate swap contracts are within the borrowing and lending powers of local authorities. This understanding appears to have been based upon commercial assumptions which developed within the money markets, not a result of initiatives taken on legal advice by either part of the transaction. When advice was taken by the Chartered Institute, it confirmed what was already understood to be the position in the money markets. The formulation of standard clauses for use in the basic interest rate swap contracts, although not designed specifically for use in transactions with local authorities, no doubt added to the general understanding there was no legal risk. It does not appear that any auditor of local authority accounts expressed doubt on the matter until the issue was raised in 1987 by the Audit Commission. So it doesn't look as though, in any view, there was a true settled view of the law, according to Lord Hope, certainly in this case. He then turns at page 5, MS 544, page 407 at the bottom, to was there a mistake? Having already said that it doesn't seem to be an issue as to whether there's a mistake, he then proceeds to determine over a number of pages whether there was a mistake.
So sorry, what electronic? Oh, I've got it.
It begins
Right.
at 5044.
Yeah,
And then if you turn over the page, he starts in the middle, just below letter C. The proper starting point for an examination of this issue is the principle in which the claim for restitution of these payments is founded, unjust enrichment. It's unjust for a person to retain a benefit which he has received at the expense of another without any legal ground to justify its retention, which the other person did not intend him to receive. Sounding a bit like a kind of civilian law description. And then he goes on to say, on the next paragraph, what then is the function of mistake in the field of restitution on the grounds of unjust enrichment? The answer one may say is its function is to show that the benefit which has been received was an unintended benefit. A declaration of intention to confer the benefit, even if unenforceable, will be enough to justify the retention of the enrichment. A mistake, on the other hand, will be enough to justify the restitutionary remedy on the ground that a benefit which cannot be legally justified should not be retained where it was a mistaken and thus unintended benefit. And then he goes on to deal with the civil law position in the next paragraph. And then on the following page, he turns back to the common law, just above B. The approach of the common law is to look for an unjust factor, something which makes it unjust to allow the payee to retain the benefit. That's Burke's. It is the mistake by the payer which, as in the case of failure of consideration and compulsion, renders the enrichment of the payee unjust. The common law accepts that the payee is enriched where the sum was not due to be paid to him, but it requires the payer to show that this was unjust. Whereas in civilian systems, proof of knowledge that there was no legal obligation to pay is a defence which may be invoked by the payee. Under the common law, it's for the payer to show that he paid under a mistake. My impression is that the common law tends to place more emphasis on the need for proof of a mistake, but the underlying principle in both systems is that of unjust enrichment. The purpose of the principle is to provide a remedy for recovery of the enrichment where no legal ground exists to justify its retention. So this is switching a bit towards the Burkean theory. To answer this question, one must have in mind both the state of mind of the payer and the state of the facts or the law which is said to have made a mistake. The state of mind of the payer must be related to the time when the payment was made, so must the state of the facts or the law. So he's quite clear that you have to look at the time of the payment. That is a time at which it must be determined whether the payment was or was not legally justified. I agree with Justice Brennan's observation in Davis Securities. The right to recover the amount paid by mistake accrues at the moment when the sum is received by the payee. The point of the inquiry is to show that had the payer known the true state of the facts or the law at that time, he would not have made the payment. The inquiry will not be a difficult one where the mistake is said to be one of fact. If the facts have not changed since the date of the payment, and the payer is able to show that he paid due to a misunderstanding of them, to incorrect information or to ignorance, in such a case, the requirement for recovery will normally be satisfied. Nor is it difficult to deal with the case where the facts have changed. In such a case, proof that the alleged state of the facts at the time did not emerge until afterwards will usually be sufficient to show that there was at time of payment no mistake. Not really quite sure what he means by this. The case may be more difficult where the mistake is said to be a mistake of law, but I don't think there's any essential difference in principle. A question of law may be as capable of being answered as precisely and with as much certainty as a question of fact, or it may be, as are some questions of fact, a matter of opinion. Yes, I'm not really very clear where this is going, nor is there any essential difference between fact and law in regard to the payer's state of mind. This may vary from one of complete ignorance to a state of ample knowledge, but a misapplication of what is known to the facts. The mistake may have been caused by a failure to take advice, by omitting to examine the available information or misunderstanding the information that's been obtained. Or it may be due to a failure to predict correctly how the court will determine issues which will be resolved at the time of payment. And then in the next paragraph, cases where the payer was aware that there was an issue of law which was relevant, but being in doubt as to what the law was paid without waiting to resolve the doubt may be left to one side. A state of doubt is different from that of mistake. A person who pays when in doubt takes the risk he may be wrong. That is so whether the issue is one of fact or law. As for mistake, this may arise where there is no suggestion that the law has changed since the payment was made. If it can be demonstrated by reference to statute or case law that the law was overlooked or was applied wrongly, the position will be the same as where the mistake was one as to the state of the facts. Well, that must be right. That would be the simple case where someone has simply paid tax, let's say, overlooking subsection 6, which said he didn't have to pay, or another section, let's say, in the Act, which he wasn't aware of, which said he didn't have to pay. That would be a simple mistake of law, and the money should be recoverable. There's no doubt that the law was what it was at the time of the payment. There would also be no doubt that there would be no, I would just submit in that case, there'd be no extended limitation period, because that would be a case where he could, with reasonable diligence, have discovered the true position by simply looking at subsection 6 or the other section. So that's a very simple case where I think everyone would agree there is a mistake of law. It's very unusual for a statute to provide for law to be changed retrospectively, but this is not unknown to the War Damage Act. If the law is changed retrospectively by statute, so that a payment which was legally due when it was paid has now become undue, the correct analysis will be that there was no mistake at the time when it was made. The enrichment will have been due to the fact the law was changed retrospectively by the statute. And
I think Hoffman took a different view of that.
he did, yeah. I think he took the view that that would generally be dealt with by the statute itself.
No, I think he said that would be a mistake.
That would be a mistake, yes.
I mean, it might be dealt with by the statute, but it might not be.
Yes.
And one's tempted to ask, well, if that's true of a retrospective change by a statute, why should it make any difference if it's done by a judge? But
that may be because that's wrong.
Well, because I think Lord Hope's answer is the declaratory theory, isn't it?
Yes, I think that's right. But I mean, that situation, interestingly, arose in the Woolwich case, the litigation, because what happened after Woolwich won was that Parliament changed the law retrospectively for everyone else apart from Woolwich. All the other building societies, there was a retrospective change to validate the statutory instrument. And there was a challenge to that under the human rights legislation, which failed, I think, in the European Court of Human Rights. But I suppose that would be a case where there was a retrospective change, which meant that a payment which wasn't due originally, see Woolwich, now became due. So Lord Hope would say they could... they couldn't recover, as he'd say. There was no mistake. And he continues, what then is a position where the fact that the payment was not legally due at the time when it was made was only revealed later by subsequent case law? In posing this question, I'm not dealing with a situation where a judgment of the court that a sum is due has become final and acted upon. It was afterwards overruled by a higher court. So that's a case where the case is finished. You've got your judgment, and it turns out later that you were lucky and you got it on the basis of the law that's now been said to be wrong. That there's nobody would suggest that would be reopened. That would be the end of that. He then goes on, the law of adjustment enrichment doesn't disturb transactions of that kind. Where the payment is made because the court has held that the sum is due to be paid, the obligation to pay is to be found in the order which is made by the court. I am dealing with the case where the payment was made on the understanding that the law on the point was settled, and that understanding was shown by subsequent case law to have been wrong. The answer to this question may be said to depend upon whether the decision question has changed the law or merely declared what the law was. And we're reminded of Lord Reid's observation that judges never change the law as a fairy tale. experience has shown that that judges do from time to time change the law in order to adapt it to change social conditions or in response to other factors which show the law is out of date. But it would be equally wrong to say that judges never declare the law. It may simply be that there was a gap which needed to be filled, or that there was a defect in thinking which needed to be revealed so that a point could be clarified. And that, I would suggest, is very much the most common type of case. To overturn an established line of authority is one thing. It's quite another where there was no previous decision on a point which no one had sought to bring before the court previously. It may be said that a view of the law can be regarded as settled even when there is no case law at all on the subject, because all those interested in it have acted on a common understanding of what the law requires. But I would find it difficult to accept that a judge who said that the common understanding was wrong, the law was different from what everyone previously thought it was, had changed the law. It would seem to be more accurate to say that, as it was for the judge to say, what the law was, he was merely declaring what the law was and that he was not changing it. Yes, I suppose I would interpose there that there can be situations where the law is established not necessarily by legal decisions. I mean, there must be propositions of law in textbooks that everyone would accept are the law, but have never been tested in court. In some cases, because they're so obviously basic that nobody would ever litigate them. I don't know, my experience is often if you're looking for an authority for a basic point, it's very difficult to find because they simply haven't been litigated. So there must be cases where the law has been established other than by legal decisions. But I don't think he's talking about that. I think what he's talking about here is simply where people have a common understanding of what the law is. And that's not enough. That's not a change in the law. That's simply the court deciding what the law is and always has been. And as I say, that is by far the most common situation. And it is the situation I would suggest in our case and was the situation in DMG as well. We'll come on to that. But DMG was not a case where there was previous authority contrary to the position. There was no authority on it previously.
Ben says it's difficult to draw the line.
Sorry?
He says it's difficult to draw the line.
Yes.
Where do you draw the line on your case?
Where do we draw the line between where there's been a decision?
Deemed case and your other case. Between your deemed case and your other cases.
Well, we would draw the line in a situation, well, certainly where there has been a decision previously. You're looking, that which is then overruled. That looks like a deemed case, we would say. And I suppose where there was law that was stated in, let's say, the textbooks on partnerships for 100 years, and everyone followed it, and then it was held by the Supreme Court that it was in fact wrong. That might be a case as well, because it might be a case where that actually was the law. I agree that that's a more difficult kind of situation. But the more common situation would be where there was actually a legal decision.
First instance decision?
Could be a first instance decision, yeah. If it wasn't appealed. Then
this case is all about a statute, which turns out to have been, in the relevant sense, void. It's almost like a payment under a contract believed to be valid. Here it's a payment under a statute, which says unmistakably you've got to pay this tax, which turns out, on analysis, to have been contrary to European law. Yes, although I suppose strictly the position is that because there has been conforming interpretations of this provision, which have led to the unlawfulness, is a case where the statute... Or was it all done on conforming interpretation, or just putting a line through it? No, it's been done on conforming interpretation. It has to have been done on that because it was so complicated. It wasn't a question of just striking out a provision. You had to introduce, well, in some cases, a tax credit in order to achieve the purpose, because of the knock-on effects on all the other part of the system. So it was all been done by conforming interpretation, yeah. Which is one of the difficulties in this case, because this is this is one of the first cases where something as complicated as this has been done by conforming interpretation. That was why we had all these issues that went to the Court of Appeal. So what Lord Hope says
at the bottom of page 411 is that, this is under G, just under G, I do not think that it would be right to say that the decision in Hazel case changed the law. What it did was to clarify a point which had been overlooked and was in need of determination by the court. But the situation seems to me to be no different in principle from one where the facts are shown as a result of inquiries which at the time of the payment were overlooked or not thought to be necessary, to have been different from what they had been thought to be at the time of the payment by the payer. Prima facie, the bank is entitled to restitution on the grounds of mistake. And then he goes on to consider all the defences. And then the other passage that I was going to come back to was on limitation, beginning on page 41, bottom of 416, 32.1c, because Lord Hope also gave a reasoned decision on that point. And just without looking at all the detailed reasoning, he relied on Envy Deplock and Casey's ex parte James. At the bottom of page 417, he says the objection may be made that time may run on for a very long time before a mistake of law could have been discovered with reasonable diligence, especially where a judicial decision is needed to establish the mistake. So he's assuming, I think for this purpose, that what discovery means is discovering it for certain. It may also be said that in some cases a mistake of law may have affected a very large number of transactions. The potential for uncertainty is very great, but I don't think any concerns which may exist on the ground provide a sound reason for declining to give effect to the section according to its terms. The defence of change of position will be available and difficulties of proof are likely to increase with the passage of time. I think the risk of widespread injustice remains to be demonstrated. If the risk is too great, that's a matter for the legislature. And then he says, we don't have this problem in Scotland. You can almost feel the ha-ha. Anyway, and that may be why there are no or very few cases of this type brought in Scotland. They're all brought in England. Can I then turn to DMG, which is even more pertinent to the issues that we're considering today? It's at tab 11 in the same authorities bundle. It's in this judgment that Lord Hoffman gives the first judgment. It's in this judgment that Lord Hoffman reiterates his point about deemed a mistake, and it says that it might make people feel happier who are criticising his judgment if they look at it as a deemed mistake rather than an actual mistake. But the relevant passage for this purpose is paragraph 30 and 31. Paragraph 30, he agrees with the judge in the Court of Appeal that they made a mistake. Subjectively, they made a mistake. They thought DMG had to pay. He then says in 31, if DMG made a mistake about the law, when could they, with reasonable diligence, have discovered it? On this question, it's important to bear in mind the special nature of the mistake, namely that it was deemed to have been made because of the retrospective operation of a later decision of the Court of Justice. The reasonable diligence proviso depends upon the true state of affairs being there to be discovered. In this case, however, the true state of affairs was not discoverable until the Court of Justice pronounced its judgment. One might make guesses or predictions, especially after the opinion of the Advocate General. This gave DMG sufficient confidence to issue proceedings, but they could not have discovered the truth because the truth did not yet exist. In my opinion, therefore, the mistake was not reasonably discoverable until after the judgment had been delivered. What you have to remember, of course, and this may seem obvious, but that other claimants made claims long before the judgment 2001. The claimants who had their claims referred to the European Court, the Hearst claimants, made their claims in 1995. And so it is a necessary consequence of this decision that even those claimants didn't discover their mistake until 2001, despite the fact they had brought proceedings 6 years earlier based on the proposition that they had made a mistake. The mistake being that the ACT was not payable. DMG, the Hearst DMG litigation, it was much simpler, a lot in its consequences. They didn't have the complications that we have in our case about ACT and setting it off. The question was simply, was the ACT in its entirety validly levied? And the effect of the Court of Justice decision was, as interpreted by most of the judges in this case, is that it wasn't validly levied. There was a complication that in order to pay without ACT, you had to make a group income election. And this was a point that Lord Scott made in his dissenting judgment, that they hadn't actually made a group income election. And therefore, the ACT was payable according to the UK legislation. But the majority took the view that this was mechanics, essentially, and that the mistake was, if you like, not making a group income election and paying when you didn't have to pay, something like that. So the majority believed that either the tax wasn't payable at all as a matter of European law, whether you made a group income election or not, because you'd been denied the right to make one, or that there was some kind of two-stage process. But in any event, the majority decided that they could recover the tax in its entirety. So that is all, and you find, so that is dealt with by Lord Hoffman at paragraph 32. Mr. Justice Park took a rather sophisticated view of the nature of the mistake. He said the mistake was not about whether ACT was payable. DMG had not made an election and therefore it was payable. The mistake was about whether DMG should have been allowed to elect. But I agree with the Court of Appeal that the mistake was about whether DMG was liable for ACT. The election provisions were purely machinery, which DMG would undoubtedly have used, by which it could enforce its right to exemption from liability. And then he deals with an anomaly that Lord Justice Buxton thought arose. The ineptitude of extending the law of payment under a mistake of law to payments of taxes. But he says that what anomalies there are flow from any recognition of payment by mistake as a cause of action, and not a distinction between private and public transactions. And then we have Lord Hope again, and he dealt with the discovery issue beginning on page 582 as MS 282. And really the conclusion on all of this is beginning at paragraph 69 on MS 284. First of all, the evidence of Mr. Thomason, which went to whether he actually made a mistake and when he actually himself discovered it. And he then says in 70, it may be said there was enough in Hearst's challenge to raise a doubt in Mr. Thomason's mind as to whether or not the law with which he faced would survive it, But the situation with which he was faced is quite different from that, where a payer is in a state of doubt about the state of the law in a private transaction, decides to pay nevertheless and take the risk he may be wrong. In such a case, the causative link between the mistake and the payment may be broken because the evidence shows that the payer was content to pay irrespective of whether the sum is due or not. In this case, DMG was in no position to do anything else but pay the ACT. It had not claimed group income relief because, wrongly as it turned out, it believed the group income relief was not available. It is plain, as the judge recognised, that if DMG had submitted a claim for group income relief under section 2471, the revenue would have pointed to the clear terms of the statute and rejected it. It has never been suggested that they would have conceded in a question with DMG the point which they were resisting so strongly in their litigation with Hurst. DMG's mistaken belief that a group income election was not available was not shown to be wrong until the issue which Hurst had raised was determined by the European Court on 8th March 2001. The issue, which was one of law, was not capable of being resolved except by litigation. Until the determination was made, the mistake could not have been discovered in the sense referred to in section 32(1) of the 1980 Act. Now that assumes that discovering means resolving the question, because he's saying that it couldn't be resolved except by litigation. And we say that's not what discover means in the context of the limitation provision. But if you assume that's what it means, then of course he's right, it couldn't be discovered except by litigation. If discover in this context means determine for sure, resolve the question for sure.
See, incidentally, at paragraph 22, Lord Hoffman addresses the point that I asked you about earlier. Remember in Climate Benson, the money was recoverable regardless of unjust enrichment, regardless of mistake of law. It was recoverable because it was a void contract. And here it's recoverable under the Woolwich principle, and that was conceded in paragraph 7, notes that.
Yes.
And he says, Lord Hoffman's saying that it's not necessary to decide the fundamental basis of the enrichment liability because the question isn't the fundamental juridical basis of a cause of action, but whether the action can be described as falling within the statutory formula of 32(1)(c). And he gives Climate Benson as recent authority for the proposition that an action for restitution of money paid under a void contract can fall within this description. So he's treating Climate Benson not as a case of restitution for mistake of law, but a case of restitution because the contract was void, but as falling within the formulation, relief from the consequences of a mistake within the meaning of section 32.
Yes, but presumably because there was a mistake as well.
Yeah.
Yes. 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 But of course it's been held, I don't know whether, by this court in the previous litigation that relief from the consequences of a mistake requires mistake to be an ingredient in the cause of action.
Ah.
So you can't
Right.
a claim, for instance, under Woolwich, you can't get a extended limitation period just because there happens to also have been a mistake.
So it's when Lord Hoffman says a few lines further down that that Climate Benson does not seem to me inconsistent with the existence of a mistake not being essential to the cause of action. That's inconsistent with subsequent authority.
Yes, that would be wrong because this court decided in the first FII case, it was one of the issues, right. If you recall, did it need to be?
I'm afraid it's a few years ago now.
I wasn't suggesting your lordship should remember. I'm sorry if I was just saying it was decided then. Because there had been there was that previous decision of Mr. Justice Pearson, where the first instance it was mentioned, where it had been said, there was nothing beyond that until this court decided it. Yes.
But elsewhere, Lord Hoffman says in terms, doesn't he, that there may be alternative causes of action, in which case you can choose whichever gives you the better limitation period.
Yes, exactly, yeah. And that, I think that's the general basis of this. You might have an action in Woolwich, you might have an action in Mistake. You can pursue both, and you have to elect eventually, I think, at some point, but you can pursue both. You don't have to choose. The existence of the Woolwich action doesn't oust in any way the Mistake.
It's a paragraph 33 in the last sentence.
Yes. Yeah. Lord Scott gave a dissenting judgment. I think he did say that, subject to what he said, he agreed with everyone else, or assuming he was wrong. And he certainly agreed. But he thought that the answer was that there should be a damages claim. Lord Walker then he deals with this particular issue very briefly at paragraph 144. It's under the heading the mistake issue. Paragraph 144, I think the judge and Lord Justice Jonathan Parker were correct in their views, and the mistake was not discovered until the European Court of Justice gave judgment in Hurst. Perusal of the report in that case suggests the United Kingdom government tenaciously defended the ACT regime on every available ground. At no time before the judgment did the government concede that the ACT regime was indiscriminatingly in national and multinational groups contrary to EU law and unlawful. It was a judgment that first turned recognition of the possibility of a mistake into knowledge that there had indeed been a mistake. I agree with Mr. Justice Lightman in First Roothill that there may be cases where a party may be held to have discovered a mistake without there being an authoritative pronouncement directly on point in the facts of the case by a court, let alone an appellate court. It all depends on the facts. But in this case, it is, in my opinion, clear that the judgment was a decisive moment. That is most clear, that is absolutely clearly based on the proposition that you have to discover that there had indeed been a mistake. What is not clear is what he thought the relevant facts might be and what circumstances there might be in which you might have knowledge that there had been a mistake without an authoritative decision. Though he appears to recognise that possibility, but doesn't in any way say what that situation might be and why this situation was in fact different. And then finally we have Lord Brown, who agreed with everything else, I think, but disagreed with the approach on this issue. So he says all that in paragraph 161. He agrees with almost all of Lord Walker's speech and the speeches of Lord Hoffman, Lord Hope. I find myself in full agreement that he would allow the appeal. On one issue, however, the discovery issue, I have the misfortune to take a different view, one that puts me in a minority of one. But it doesn't make any difference, he thought. 162, as I understand it, your lordships have concluded, first, that DMG was acting under a mistake of law when making the 3 relevant payments of ACT. It's on this issue that my noble and learned friend Lord Scott dissents on the basis DMG was in any event under a legal obligation to make the payments and should not be regarded within Clymer-Brenton principle of having made them under a mistake of law. Secondly, the mistake was not discovered until the decision of the European Court in Hurst was handed down. The contrary view which I take is that the DMG ceased to be acting under any relevant mistake of law in July 1995 when they first became aware of the Metal-Gesellschaft Hurst proceedings and recognised that there was a serious legal challenge to the legality of the UK's ACT regime under EC law. If I'm correct in this view, it would follow that DMG, although paying the October 1993, February 1995 payments under a mistake of law, discovered that mistake in July 1995 so as to set time running in respect of those particular payments as from that date, and that the January 1996 payment was not made under a mistake of law at all. Then he says 163, let me turn then to this narrow though potentially important issue on which I diffidently disagree with your lordships. Then he sets out 32.1 and he says it is, I acknowledge, difficult to articulate the precise touchstone by which to determine whether a payment ought properly to be held to have been made under a mistake of law, or indeed answering essentially the same question from a different standpoint, whether such a mistake should have been held to have been discovered or able with reasonable diligence to have been discovered. Section 32 itself affords little help on the question, unsurprisingly, perhaps given that the provision was framed at a time when no plaintiff could have hoped to pray in aid a mistake of law. For my part, however, I would hold that as soon as a paying party recognises that a worthwhile claim arises, that he should not, after all, have made the payment and accordingly is entitled to recover it, or as here, to compensation for the loss of its use, he has discovered the mistake within the meaning of Section 32, and by the same token, I would hold that if he makes any further payments thereafter, they are not to be regarded as payments made under a mistake of law. Where I would ask respectfully, is there any injustice in this? No one is suggesting, let me repeat, that the monies are not recoverable or that the payee should remain unjustly enriched. All that is required is that the payer does not sit upon what hypothesis he recognises to be a worthwhile legal argument for more than 6 years. Provided he acts within that, surely ample time, he can pursue his claim, whether in respect of past payments or indeed payments he may choose to continue making, under whatever may be the appropriate cause of action, restitution for mistake of law in respect of past payments made when he had no reason to question his liability to make them, total failure of consideration, or a claim based on the Woolwich principle. Once a plaintiff recognises that he has a worthwhile case on the facts to pursue a claim in fraud or to extend the limitation period for a particular claim because of the defendant's deliberate concealment of a fact relevant to his cause of action, time surely then starts to run against him under Section 32. He could not successfully argue that time starts running only when the court eventually comes to reject the defendant's denial of wrongdoing and to find fraud, or as the case may be, deliberate concealment established. Well, he's right about that, and we'll see. There's case law on this. Nor do I find it easy to reconcile the approach taken by your lordships with other provisions of the 1980 Act, most notably Section 14A9, as inserted by Section 1 of the Latent Damage Act. Knowledge that any acts or omissions did or did not as a matter of law involve negligence is irrelevant for the purposes of subsection 5 above. Section 14A5 determines the starting date for reckoning the period of limitation based on the claimant's state of knowledge. As Lord Nichols of Birkenhead recently observed in Hallward, a claimant need not know he has a worthwhile cause of action. And that's exactly the point we make, and that's how these provisions have been interpreted in the context of personal injury, etc. On your lordship's view, however, such a claimant could well argue that he was labouring under a mistake of law so as to extend time under Section 32.1. The Woolwich case was decided on the explicit basis that the Building Society was in no way mistaken when making its payments under the disputed regulations. See particularly the speech of Lord Gough, Lord Slynn. Rather, the payments were made because, as Lord Gough put it, and then he quotes what Lord Gough said about why Woolwich paid. I can see no real distinction between that case and this. True, as Lord Gough observed, Woolwich was convinced that the demand was unlawful, whereas here Mr. Thomason, DMG's head of taxation, believed the company was in law bound to make the payments, precisely indeed as Lord Scott would hold to be so. But I fail to see why the question whether monies are paid under a mistake of law should turn on the degree of conviction or optimism which the parties hold upon the legal issue dividing them. Were the claimants in the Hirsch case, who issued their proceedings against the revenue in 1985, nonetheless to be regarded as having made all subsequent payments under a mistake of law? Surely not. Even DMG itself, will have been noted, brought its claim in October 2000. It is nevertheless to be said that their original mistake remained undiscovered until the European Court of Justice's actual decision in Hirsch some 5 months later. And this is a point that we make, and it is a dissonance between how the courts look on whether you've made a mistake and then how they look on whether you've discovered your mistake. And I'll come back to that, but the question of whether you made a mistake seems to be a factual question determined on what you believe the law to be. So, for instance, Woolwich, everyone says Woolwich didn't make a mistake. They believed that the regulations were ultra vires. They hadn't been determined to be ultra vires. It was years later that they were authoritatively determined to be ultra vires, but they didn't make a mistake. But it said if you did make a mistake, you couldn't discover that mistake until the court has authoritatively told you about it, there does seem to be something wrong with that. Actually, I'll come back to that when we're looking at the anomalies. In Claimant Benson, case, as I understand that case, nothing turned on the particular state of mind of the payer as to whether the payments for which restitution was sought were made under a mistake. As Lord Hope noted, the only issue on that part of the case was whether the bank's mistake was one of law. It was certainly not critical to the decision that the mistake of law was assumed, at least by Lord Lloyd, to have been discovered only when the House of Lords finally held in Hazel the swap agreements were void. Then he quotes Lord Hoffman and then Lord Hope. On the present appeal, however, Lord Hope concludes his judgment on the discovery issue of his speech with the view that when DMG paid the ACT, it was not then obvious that the payments might not be due. I confess to some difficulty with that conclusion. Surely when DMG learned in July 1995 that there was a serious legal challenge to the legality of the ACT regime, it must then have been obvious to them that these payments might not, after all, be due. Of course, they could not be sure, and of course nothing short of a final judgment from the European Court of Justice would have persuaded the Revenue to accept any claim by DMG here for group income relief. But it does not seem to me to follow that DMG paid under a mistake of law, any more than Woolwich would be regarded as having paid under such a mistake simply because the Revenue in that case were insisting on the validity of the contested regulations. I have the same difficulty with paragraph 144 of Lord Worker's opinion. Again, I see no good reason why the Revenue's tenacious defence of their position and their refusal to concede its unlawfulness means that DMG's mistake must be treated as undiscovered prior to the judgment in Hurst. The passage Lord Walker quotes continues, "For this purpose, it cannot be necessary that the party knows of the mistake as a certainty. There are gradations of knowledge that may well be sufficient to constitute the necessary discovery that the claimant has good reason to believe that a mistake has been made, or has been given a line on this question." To much the same effect as Lord Justice Morris Kay's judgment in Brennan. This, the plaintiff's extreme difficulty in obtaining permission to appeal and small chance of persuading the Court of Appeal, it seems to me falls short of the unequivocal but mistaken view of the law which underlay the Clement Benson case. As Lord Hope observed, the House of Lords was not dealing with the case where there is doubt as to the law. A state of doubt is different from that of mistake. An appeal might have been correctly perceived as an uphill struggle, but not as inherently insuperable one, as subsequent events were to prove. Lord Hoffman suggests at para 26 that the real point is whether the person who made the payment took the risk that he might be wrong. If he did, then he cannot recover the money. But my thesis is not that if someone pays money knowing that he may not be under any liability to do so, he cannot recover it. Rather, it is that he cannot recover it as money paid under a mistake of law, so as to benefit from the longer limitation period available under Section 32. Certainly, he can recover the money provided only that he sues in time and has some other cause of action, such as total failure of consideration. Clearly, the quiz contestant who, in doubt whether Haydn or Mozart wrote Eine kleine Nachtmusik, answers Haydn, made a mistake. Suppose, however, that making that mistake, he had paid out money legally due only if Haydn had been the correct answer. To my mind, he, no less than the quiz contestant, took the risk he might be wrong. He could not recover his payment as money paid under a mistake of law or fact, although, provided he sued within 6 years, he could well recover it on other basis. The precise point at which a party may be said to be or to cease being under a mistake of law is, I acknowledge, by no means easy to formulate. Just when a party comes to recognise as a worthwhile claim, the touchstone I have suggested will not always be obvious. Essentially, however, I'm in broad agreement with Mr. Justice Lightman and Morris Kay's approach in the cases mentioned above, as indeed I am with the views of the majority of the Court of Appeal on this issue. Now, one thing you have to remember, note when looking at Lord Brown's judgment is he's only looking at the question of whether when the claimants discovered their mistake. He's not going on to consider the further question, when could they have discovered their mistakes, which is the issue that we have. And we would say Lord Brown was right as far as he went. They discovered their mistakes, as a matter of fact, possibly when they learned of the Hurst claim. But that doesn't answer the question, when could they have discovered their mistake with reasonable diligence? And the answer to that may be much earlier. So I was going to turn now to, having looked at the two leading cases, turn to the reasons that we say that the Court of Appeal's approach following DMG is unsound. And we've set these out in our case, you'll have seen. And I'm going to deal with them under the same headings. The first is the uncertainty. It's often claimed that this is at least a certain rule. It may be a bad one, but it's at least certain. But we say that's not necessarily the case at all. A number of questions arise. What is an authoritative resolution?
Where are we in your case?
Which paragraph is it? Oh, yes. 56, yeah. It begins, paragraph 56 is where uncertainty begins.
Yes, thank you.
E page, please.
3935.
What's the...
Thank you.
Yeah. Sorry, 3935?
Yeah.
MS. Yeah. So, even if you take the case at the rule at face value, does the decision have to be strictly ratio? We all know about the difficulties of deciding what's ratio of a case, particularly if the court decides 2 points. That's always a problem. They decide 1 point first. Is the second point ratio or obiter? Is that an authoritative resolution? And even more puzzlingly, what does the Court of Appeal mean where it says, at least where it is being actively disputed in current litigation? It seems to suggest that this rule only applies where, as it says, the matter is being actively disputed in current litigation. But of course, at some point in the past, it would have been disputed when the payment was made. And for a period after that, you still have to ask the question, could the claimant, the putative claimant, could he, with reasonable diligence, have discovered the mistake? So, how do you determine it in that period? It doesn't seem to really make much sense to say where it's being actively disputed in current litigation, then there is this rule that you wait till the end of litigation. Could the mistake have been discovered before the litigation begins? And then you have the difficulty, what did Lord Walker mean in the paragraph I showed you, paragraph 144, where he says it's all a matter of fact? What are the facts? So, we say it's a bad rule, but it's also by no means clear. It doesn't produce certainty. Then the second point is the paradoxical implications. And this is something that's been pointed out in a number of cases. The claimant can commence an action based on mistake many years before it discovers its mistake, according to this rule. So DMG issued its claim form in 2000 and the ECJ decision was in 2001. We know that Hearst issued their claim form in 1995 and the decision was in 2001. BAD issued its claim in 2003 in this case and the decision was in 2006. Now Mr. Justice Henderson thought this was paradoxical, but he thought he was compelled by DMG to that conclusion. And that you'll find that at paragraph 454, 465 of his judgment at first instance in this case, which is Core Volume 2, page 694, MS 4739.
4739?
4739. So first we have para 454. He says, since the claim form was issued on 18 June 2003, the proceedings were clearly begun well within the relevant 6-year period, even if it started to run in March 2001. This explains why the question is of no practical significance in the present case. But it also brings out what may at first sight appear to be an insuperable logical difficulty in the claimant's case on this issue. how can it be said that they neither had discovered nor with reasonable diligence could have discovered their mistake until 12 December 2006, when they'd already started the present action, including the mistake claim, 3.5 years earlier? And then he goes back to that at paragraph 465, which is on MS 4742, page 697. He says, in the light of the approach to section 32(1)(c) adopted by the House of Lords in DMG and the history of the DMG litigation itself, as described by Lord Sumption in the FII Supreme Court, I consider that the date when a mistake is discovered or becomes reasonably discoverable for the purposes of section 32 may in principle be a date later than that on which the actions based on the mistake was started. A well-advised claimant may begin proceedings at a time when the law is still objectively unclear. That was a position in my judgment in relation to the claimant's mistake-based claim on 18th June, and the uncertainty was not finally resolved until the House of Lords delivered its judgment in DMG on 25th October 2006. So what he's saying is that on the basis of DMG, because discovering a mistake means finding out for sure the answer that you're mistaken, then you can bring proceedings before it. The same paradox was considered by this court in AB in the Ministry of Defence, which is a case about the sections 11 and 14 of the Limitation Act. That's in Authorities Bundle 1, tab 7. These were claims against the Ministry of Defence. And the
Page?
Sorry, it's MS 40.
40. Thank you.
It's claims by servicemen who claimed that they were subject to radiation and suffered damage as a result of that. I'm going to come back to this case because it's quite important for the way that the test was set out. I mean, the position here was that they brought their claims at a particular time. It was then said that they were out of time due to the operation of the Limitation Act. And the question turned on when they had sufficient knowledge for the purposes of section 11 and 14 of the Limitation Act. And one of the questions was, could they be in a position that they didn't have sufficient knowledge at a time after they brought their claims? And you'll see that the court thought that was paradoxical and thought that was legally impossible, as we'll see. So Lord Wilson dealt with it at paragraph 3, it's MS 52 to 53. So there was a split in the court in this case. There was a 4-3 division on the approach, and that's also important. We'll see. He says there, the assumption that in an inquiry under sections 11 and 14 of the Act, the cause of action exists leads me with inevitable discomfiture to a profound disagreement with one of the essential foundations for the conclusions of the minority of this court. It was a preferred view of Mr. Justice Foskett, upon which he would have acted had he not felt constrained by authority to act otherwise, that the veterans who issued their claim on 23rd December 2004 acquired the requisite knowledge of attributability only on a later date, namely 29th June 2007, when the Rowland report was privately presented to them. It is the conclusion of the minority that A, it is indeed possible for a claimant to lack knowledge of attributability at the time when he issues his claim, and if so, time will not have begun to run against him. And irrespective of whether the later presentation to them of the Rowland report led them to acquire it, the veterans lacked such knowledge when they issued their claim, with the result that none of them is time-barred. In my view, however, it is a legal impossibility for a claimant to lack knowledge of attributability for the purposes of section 14.1 at a time after the date of the issue of his claim. By that date, he must in law have knowledge of it. Pursuant to CPR 22.1, he must verify his claim form by a statement he believes the facts stated are true. The word in statement of truth is believes rather than knows, only because, of course, the assumption that the cause of action exists does not apply to the claim form. That it exists is indeed only a claim. Although the statement of truth covers wider grounds, it can, in my view, be regarded as an explicit recognition by the claimant that he has knowledge of attribute for the purpose of section 14.1. So Lord Walker, all four of the majority decided in the same way. Lord Walker, at paragraph 66, which is MS 73, he says, I do, however, have reservations about Lord Wilson's proposition, concurred by Lord Mance, that the effect of the statutory provisions is that the claimant is assumed to have a cause of action. No doubt this is correct in the general sense. Every claimant who issues a claim form commencing contentious proceedings is assumed to have a cause of action unless and until his particular claim is struck out, or the action is discontinued or dismissed. But I do not see that this general assumption helps, and it may actually be a distraction in understanding the way that sections 11, 14 and 14 operate. The putative character of section 14 and section 1b and 14a8a depends not on any implicit assumption, but on the long-standing consistent meaning which courts have given to attributable. So I'm inclined to think that this is a novel and unnecessary refinement. And then he goes on to say, like Lord Wilson and Lord Mance, I most respectfully disagree with much of what Lord Phillips' reasoning. I do not see how a claimant who issued a claim form claiming damages for personal injury can be had to suggest that he did not, when it was issued, have the requisite knowledge for the purposes of the 1980 Act. More generally, I consider that the practical result of Lord Phillips' analysis would be a situation that Parliament can't have intended when it enacted these provisions. It would mean that persons, and sometimes, as in this case, large groups of persons, with a belief that they had suffered personal injury through the fault of a government department or local authority, or any other public sector or private sector body, but with no real prospect of proving legal liability on the balance of probability, would be able to keep their claims on ice, as it were, for an indefinite period, in the hope that one day the right evidence might turn up. As we'll see when I come back to the case, the audited thing about this case is all of the court agreed, I think, that the claimants had no claim, even at the date of the hearing in the Supreme Court, and that their claims would have been struck out. However, the majority still concluded that the limitation period had started to run and indeed had expired by this stage. So the limitation period can start to run. You could have sufficient knowledge to start the limitation period, and it can run and expire before, at a time when you do not have any prospect of proving your claim, because you don't have sufficient evidence to prove it. But that is the very obverse, I would suggest, of the decision in DMG, which is that claimants in mistake of law cases can wait until their claim has been established, and they then have 6 years to bring their claim. But claimants in personal injury certainly can't do that. Very opposite. Sorry, I'm dealing at the moment just with the narrow point about the timing. Lord Brown, at paragraph 71, makes the same point. He says, although Lord Walker in the previous paragraph expressed reservations about Lord Wilson's proposition that the effect of the statutory provisions is that the claimant is assumed to have a cause of action, I do not myself understand these reservations to amount to any ultimate difference in approach. Rather, it seems to me that the only point Lord Wilson and Lord Mance are making when they say that in deciding whether a given claim is statute barred, the court has to assume that the claimant has knowledge of the facts necessary to support his pleaded cause of action, is that the claimant cannot at that stage be had to suggest otherwise, i.e. just what Lord Walker then says in the above quoted para 67. In short, once a claimant issues his claim, it is no longer open to him to say that he still lacks the knowledge necessary by reference to sections 11 and 14 to set time running. And Lord Mance said the same thing.
Lord Brown doesn't seem to have seen any link between that and what was said in DMG. Indeed, I don't think DMG was cited, so no. So in your way, or the parallel you're drawing is clearly not one which occurred even to Lord Brown, who might have been thought to favour that.
Well, he didn't mention it here. He did mention it in in DMG did mention the Section 11 and Section 14
Yes.
jurisprudence.
But when he had the chance to sort of say, or maybe he kept quiet because he thought no one might notice that the majority were adopting his approach. Not sure.
Well, the majority are adopting it, and this has been the approach pretty much throughout. The interesting thing is the minority, as I'll come back to it, took a different approach to the start of the period in this case.
Yep.
Yeah.
I mean, the clearest statement is really Lord Walker, where you...
Yes. And then we have paragraph 83, Lord Mann's. These passages indicate that courts, by using the word reasonable belief as part of the description of the requisite knowledge, are focusing not so much on whether or how far the belief is evidence-based, but more on whether it is held with a sufficient degree of confidence to justify embarking on the preliminaries to making a claim, including collecting evidence. There's a degree of circularity about such a definition, but this is probably inherent in the concept of knowledge in any context, and he compares it with an insurance case, where in the different context of affirmation I described it as a jury question. If a claimant is pursuing proceedings which he has issued for personal injuries and his state of mind when he issued them was in substance no different from his state of mind for more than the 3 years prior, then in agreement with Lord Wilson and the passages he cites, I find it difficult to see how he can claim in those proceedings that he lacks sufficient knowledge of the facts asserted for the purposes of the Limitation Act. The other...
Well, I think
That's
time
1
is
o'clock.
time is running against you.
I was running it. I'll come on to the other inconsistency after lunch.
2 o'clock.